Great. So welcome to our first live panel discussion for the day, where we're discussing the future of the industry post the law number 6 in the post-COVID era. So before we start the discussion, I would like to introduce you to our panel. We have here with us Mr. Samuel Joshua, who's also popularly known as the OA Ninja. And also we have with us Mr. Kanakaraj Guruswamy, the Director, Owners of Affairs of DR Community Management. And also joining us in this panel is Mr. Waqar Hassan, the CEO of Etihad Community Management. And the session is moderated by Mr. George Morris, the trainer and senior consultant of Dubai Real Estate Institute. So viewers, please note that the Q&A will be held in the last 10 minutes of the discussion. However, we do encourage you to post in your question during the course of the discussion. And of course, we do have a networking lounge where we can take the discussion out there post the session. So over to you, Mr. George.
Good afternoon, everyone. It's a pleasure, as usual, to have you as audience, and of course, the esteemed speakers that we will shed the light on the new law that came last year, law number 6, 2019, after a long time of using the old law. Now, we expect that the new law will add lots of good news to communities, to ownership, to investors, and to Dubai specifically. Unfortunately, we're hit with this COVID-19 at the beginning of the year, which has held lots of activities for everyone in this country. However, we can tell that with the leadership of the country, we have reached the best levels of safety, security, health possible we can reach. I'll be moderating this session between three of the big ones in the industry of owners association and management companies in Dubai with vast experience and input and really lovely background when it comes to professionalism. I will start by asking Mr. Samuel a question, and I hope that we get to hear the lots of innovative ideas. How, Mr. Samuel, had the new law changed the way common areas will be managed?
Hi, my name is Sam. Yeah, it's a great question, George. Thank you for the question. Yeah, has the new law changed, the way things are being dealt, right? My answer would be yes, definitely. In the past time between the law coming in place and making a lot of changes, what I have seen personally is that the way things are being managed and the way the board members are getting involved have changed dramatically. Previously, it was just people understanding what was happening and the legality of owners association in place, like DIFC compared to Dubai was always a different kind of way things were happening. But right now what we see is that there is a blend of the legality and the law, and also looking at ways of how the owners association is able to manage all the common areas as well. Previously, it was more of a certain committee members or certain people who are just getting themselves introduced to the owners committee and making sure that the common area is taken care of. But right now what we see is more of an active involvement. So I have personally seen a lot of involvement with the new law, and also people understanding how the law gets them to manage the common area. And also as committee members or committee owners, committee members, they are able to look at how operationally things are being done, and also understanding how what's the impact. It's not just about people saying, I want my common areas to be proper. It's more of working with the managers now. I believe the law has enabled people to understand what is expected out of OA management companies, FM companies, and also the committee members. This is much more established nowadays with the introduction of the new law.
Sounds good. Mr. Waqar, if you can tell me, in view of the new law and the owners committee that will be assigned or is assigned by the land department or RERA, what is the main role of this owners committee?
George, the owners committee has effectively replaced what was previously known as the owners association board. Before I shed light on the role of the committee, I'll just extend a bit to what Sam said. Uh, it has changed the way common areas are being managed. Earlier, there was a diffusion of responsibility, or a vacuum was created where the developer was in control, the developer called the shots. But wherever the developer was not actively involved, so somewhere it was owner, somewhere it was the management company, but there was a general lack of accountability, or who is the responsible party. So, it's in each project, it was, whoever got control was exercising power. So the new law has effectively, holding management companies accountable for the management of common areas. And earlier, owners' participation was through the boards. So the boards had a lot of executive power, and because the owners' associations were not registered, the boards did not have a legal capacity. They did not have a legal capacity. So there was, again, it was causing a diffusion of responsibility, and it was a gray area whether the board had any legal power or not. So that gray area, or uh, confusion, has effectively been eliminated by the new law. So the committee has the responsibility as a representative group, and their responsibility has been very well clearly defined in the law. They need to act as a bridge between the management and the owners. They can collect feedback on how the common areas should be. They will give feedback to the management on the budget, the service charge budget, and they will keep an oversight on the management. However, the committee does not have any executive powers, so that has been taken out from the scope, and management is responsible for the execution. However, the committee acts as a representative of the customers, and this is my take on it.
You mean representing all the other owners?
Yes.
In other words, they are observing what is the master developer or the company management company is doing, and reporting that together with any complaint that any of the owners might have to the land department or owner RERA.
First to the management company, and if that is not resolved, then there is an escalation procedure that they can, escalate the matter to RERA if management company has not been able to resolve that problem.
All right, elaborating on this, Mr. Garage, if you may tell us, what is the system of electing or appointing or assigning this 9 members of owner committee?
Thank you for the questions. It's very important. Currently, under the RERA supervision, RERA has come up with a beautiful solutions which makes every individual owner or committee member who want to be volunteer himself or herself to be part of the committee member. They made the solutions very easily. And every community, by law, it allows maximum 9 members can be a committee members. But the committee selection process or appointment process made it very simple to the owners who want to be volunteer. And they have made the system which called as a REST. If you can, it can be downloaded from any of your mobile app or either Android or Apple. And if you become a owner, you select your building, and once you select your building, you have to use your credentials to enter that login credentials as being owner. Then you have to select your building where you want to be a committee member and upload the basic informations, basically code of conduct, those kind of informations, and it reaches RERA immediately without going or anywhere else. So the steps to be registered as a committee members have been clearly explained and sent it to every single owners from the land department itself. So as a owner, you want to be a volunteer, and you can always go and follow the simple process in infographical way explained, and that process takes to the owners to reach to the RERA. Thereafter, RERA evaluates and accepts based on their evaluation. The criteria would be simple. You have to be a resident. First
resident of Dubai, or resident in this project?
And of the community, whichever you are applying.
Okay. Right.
Second thing, you have to fulfill your service charge obligation 100%. So that's the second criteria. And third criteria as a code of conduct, and as usual, the basic information to be submitted. So that's what the minimum, minimum requirements as a owner to become a committee member.
In other words, through the REST app, we can apply to become a member of the owner committee. We have to be residing in the project we represent. That don't you see in this point that all foreigners who are living abroad, they don't have the chance to join this committee?
Yes, that could be one of the things, but the whole idea is to bring the harmony within the community. Is that when you are there and living in this community, you can bring more. It's basically they are just bringing the more committee members who lives in the building, who understand the building much better, who gives the better insight of the building to the community manager.
Absolutely.
And working with the community manager, bring the better solutions or betterment of the community. Basically,
is this process continuing? That means I can still go and apply to become a member of this committee, or once the 9 members have been elected, I cannot join?
They have given options. You can still apply. Your application still remain with them, and there is no rejection here. So you can apply there. If suppose maximum they obtain, the next any committee member step down, you automatically be joined as a member. So also they are giving a governance the guidelines the RERA is issuing, which will give them more clear in terms of their roles as well. So it's all been well set, established by the RERA.
Thank you, Mr. Kanagaraj. I appreciate your answer. Let me take one more question to Mr. Samuel. What are under the new law, the different 3 categories of buildings that the law has specified, and the different way to manage each one?
So when you're looking at the way RERA has, done the 3 classifications is the master developer, it's not on top of my head, sorry for that. But the 3 categories are basically what they are trying to do is major developers managing their projects, hotel and retail, and then you have category C, which is more to do with community management buildings. These are the buildings that we manage as community managers. Everything else is master communities and also hotels and retails and everything. What I want to talk about is also in reference to what Kanagaraj said, right? When RERA has designed all of this, they have taken into consideration the people that actually live in these communities and also the people that are investors. So when RERA has designed the law, they have designed to give place for those people that are actually in the building and making sure that they are living in the building. And it's not just an investor, because there are 2 kinds of investors. One is who's living in the community and making sure that the community is taken care of. And you have another investor who's, let's say, outside the country, wants his basic 6% or 7% return and wants to enjoy the benefits of, just buying into that community. So by giving the power of, the committees to the people that actually reside in the building, RERA has done an excellent job of making sure that people who are looking at and joining communities also understand what's the historical issues of the community, and they are not
experiencing the same situation.
Exactly. Yes. So it is something that needs to be appreciated, and it is a great thing. So in terms of classifications, if Bakar could also help me out, or Kanagaraj could help me out, what are the 3? Yeah, what are the 3 classifications?
I can tell you there's mega projects. We call this as classification 1, which is again the mega projects as per the land department category, which is most comes under master community. That's called as a category 1. The second project is hospitality projects, which comes, where the hotel, service, apartments concept kind of things will be there. The third project is called as real estate projects, category number 3. Whichever doesn't fall the category 1 and category 2, the rest of the project all comes under real estate project category, where the community management. In terms of the management perspective, yes, the mega project is appointed and managed by the master developer themselves, or the experts, or which is the community management companies. Or the second project, it's managed by the hospitality team itself and appointed by that, there could be an operator who has the license. Third is the real estate projects, which is category 3, is managed by the community management company, regardless of what is it. It's again, the categorization comes from the land department. The land department, how the project was registered and approved. Hope that I cleared.
Good. Mr. Wakar, if you may shed the light on the role of the developer in the three categories, and if a developer still can become a member of the owners committee.
So as Anagraj was explaining, three categories. So there are large-scale projects. Large-scale projects are completely left to the developers how they want to manage and run because of their special requirements and special needs. Then the hospitality, the hotel projects, they are also left to the developers or the hotel operators the way they want to manage, and there is no requirement to have owners committee for either of them. So everything else falls under the third category, and where an owners committee is required. So where the owners committee is required, the the criteria is when the developer has sold 10% of the project, the owners committee must be established. So that is point one. Now, the other part of your question is whether the developer can be on in the owners committee. So the law does not really give any special privilege to the developer to be in the owners committee as a developer. However, if developer owns any units, so as an owner, the developer can also be part of the owners committee. So that will be a fair treatment. Like the developer does not enjoy any special privilege as long as they have the units, they can be on the owners committee.
Talking about the committee once more, Mr. Wakar, how long this elected committee will stay on board and then they can be changed?
I think that is not specified in the law. Correct me, Kanagraj and Sam, if it is, but I don't think so. There is a duration specified in the law, but they will remain there at the discretion of RERA. RERA may open the nominations for committees again, but I have not come across any.
Very good. Very good.
term
Mr. Kanagaraj, if you tell me, how does the new law address service charge areas?
That's one very good point. The new law is it's I would say that it 100% resolves the community management's the service charge collections 100% handles it because
talking about
it's
collection
complete
only, yeah?
shift. And we talk about service charge collection here, so it's completely shifts the way that we operate before the law came into play. Now the law, it's made very simple. The service charge collection could be simple after sending invoices to any individual owner. Then 30 days time the owner has to settle the dues. If the owner failed to settle within 30 days the dues, the management company may issue the legal notices or reminder notice, we call this, from the land department system itself, which is MOLAC. Okay. As soon as the owner receives the reminder notice, there is 30 days time to settle the dues. If 30 days time the owners fail to settle, that means the management company immediately can lodge a request through rental dispute center, which is also enabled already. So the exercise is already done, and on the application immediately the resolutions also can be obtained. So you can execute very easily. It's all in digital way. You don't need to even run through anything, here and there. It's 100% digital way. And the process also made it simple. That means I issued an invoice 60 today. Within 60 days, I may expect to get this, if at all worst case scenarios. If at all that it exceeds, maybe taking a week or two to complete that entire payment process. So it's made it very easy. I think that every company, management companies, are going through the process currently. The processes are very well streamed and established, and all on 100% digital.
Did the law address the point of late payment of those service charges?
At the moment, there is no late payment fee applied because considering the current scenario, etc. Yes, that in future that RERA may come up with some sort of mechanism to be applied. But now you don't need to reach the late payment stages because the system's already allowed you to execute the powers or execute the process to get this payment to be done. I think it's very well done. We have to thanks to RERA and the mechanism what they put. That's what the regulator plays a very, very bigger role.
We'll thank RERA. We thank you for the clarification. Mr. Sam, do you think the new law will contribute to attract more investors to Dubai, and how?
I definitely believe so. It's actually a very good idea to make sure, because when we look at the real estate in Dubai, you're looking at the previous experience of Dubai back in 2008, or the real estate in general in the world, but what has happened in 2008. And with the introduction of RERA, we had a general law, but now since it's diving in and making sure that the law is more particular on how things are being handled and how real estate is being handled, and also the stability of the great government that we have in Dubai, and also how it is looking at real estate investments, because most of us are expats here, okay? And it's very hard when you go into a country to invest your money, as a citizen of another country, you're expecting transparency, and that is what Dubai is providing. And with the introduction of RERA, where the voices are being heard, it is easy to understand that your money is not going to go to the drain, because there have been so many countries that have been mimicking and trying to make sure that they are following the style of Dubai and bringing in investors. Because let's face it, when investors are coming in, your economy gets boosted, and when investors are not coming in, your economy goes to the drain. So, however, in the case of Dubai, since the introduction of RERA, you can see that a lot of laws are put in place so that the investors are making sure that they pay the service charges, and also the developers are completing their projects on time. So it is a positive attitude that was needed, and with the introduction of the new law, I believe this is going to attract a lot of investors.
That means we are trying to build here the confidence and the trust. So the new laws has really give us some opportunity to enhance the trust and confidence in investing in Dubai.
Yes.
All right. Okay. Mr. Wakar, what major changes did the new law make to the management companies?
Well, as I said this before, the management companies are now held accountable. So the entire responsibility of running these projects is now on the shoulders of the management companies. So earlier there was a diffusion between the developer, the owners association, the owners association board, and the management company. So whenever there is diffusion of responsibility, things fall through cracks. But now with the new law, there is one entity or one party which is completely responsible and fully accountable for the operations of the project, and that is management company. So that is a bit clarifying and assuring that who is responsible. So that has been identified.
So let me just give you one question that came on the chat regarding the same issue. It says, what is the forum viewpoint on the enhanced accountability placed on the management company's entity under the new GOP laws, jointly owned property, vis-a-vis the fees charged by the management entities itself?
I think this will take its course, because the new law is a change. It has changed the way things are done. However, the change is not rapidly rolled out. So once the change is there, so the new law also requires that the management company provides a bond or some sort of a guarantee for performance. So all these things RERA is slowly rolling out. And I think because now the management company bears more risk, seeing in the long term, that will have to show in some sort of reciprocation in the management fee as well. But I think that this is going to be rolled out slowly.
One more addition to this. Who signed the contract of supply and contracting? Is this the management company who does this, or somebody else?
Management company. Post the new law, it is the management company which is entirely responsible for the operations of the.
Thank you, Mr. Wakar. Mr. Kanagaraj, had the new law addressed issues that were not really clear or addressed in the new law, in the old one, I mean?
In many aspects. In many aspects, we have to say that one is the transparency aspects. The new law, it's 100% addressed, because the invoices comes from
RERA.
Land Department or RERA itself,
Yes.
which is reviewed by multiple parties, which was not the case earlier. It is not something. It's the case earlier also same, but the visibility become more because they introduced a system as Mulak. That's one good thing. Second thing, the way we manage that, what Wakar was explaining, the management entity or manager is a manager is just managing and supervising. That remains accountabilities with the association of the building. Now the management entity replace one association, the complete shift change is happening. So those clarity and all brought by new law. and they introduce the committee members. You can see there's various things, introduction of a rental dispute center on addition to the collection charges. Then what we could see in the recent times, there are changes slowly, gradually taking input of every stakeholders and they're implementing. That means the careful evaluation of the law and the implementations are happening, which was not in the past cases. So I would say that it's very, very good progress. This will bring to the community or the industry in a best. I think it's going to be one of the classical example where every country could possible adapt the changes what they're implementing in Dubai. So this all the points were addressed, including clarity on the projects in the categorization also was not there in the earlier cases, which is, and each category who's supposed to manage also. I'm just giving you very high level, but definitely the new law bring lot of changes, lot of clarity, and that's progressively put in order. That's what I could say.
If the new law has brought lots of clarity and lots of involvement of issues that were not addressed before, Mr. Sam, can you tell us what is the role of Mulak in the new law?
What we see is, you have basically multiple parties. You have the developers who, create the project. You have the investors who invest into the project. And then you have basically people that are not either interested or invested, but you basically see them running the project like the tenants. So what has happened is Molak has introduced multi-layer concept where, they are making sure that the developers are accountable, right? And also they are making sure that the service charges don't get unpaid, like people who just buy into the property and don't pay service charges for the next 10 years. It becomes an issue where a community has a lot of receivables. And without receivables, what happens is that your community gets affected. As an OA management company, you lose your credibility with your good suppliers because you have suppliers where you have not been able to pay them, and your credibility goes down the drain. You are not able to pay them. And basically they go around the market saying that the management company is not doing good collection of service charges. So with MOLAC being introduced, you see that all the layers of people, the strata layers are affected. So when it comes to the developers, right now, developers have to give more accountability to RERA and DLD. You have customers or investors who are to make sure that their service charges are paid. And also with the new introduction of, RERA Ijari services not being offered to people who have not paid their service charges, where the tenants are also in check. So I believe with Molak, the concept of Molak, going back in the days, I used to talk to Ahmed Hamdani all the time. How is this going to work? He just used to say, just wait and see. So what we understand is that at this point in time, what has happened is this Molak being introduced has affected every layer. Previously, certain parties believe that they can get away with doing things, but right now you can see that every party has to make sure. It's like a big family, big families. You give your sorry.
Does it give more details on the payment and how much you pay and where has been this money used for and so on?
Exactly, it does. With like what Kanagraj said, with the introduction of Molak and the invoice coming directly from DLT, you can actually see the details being listed in the paper. So previously, it was just a management company that will print an invoice and give it to you. And as an owner, I'm an owner myself, and I used to question whether this was really proper. But with right now, DLD sending you the invoices, it becomes extremely transparent. And it also becomes extremely, at the end of the day, you're not going to be fighting with the customer, rather say, this is from the DLD, the paper is from DLD. It has nothing to do with us, and there are layers of check, which is helping you as a customer, and it's also helping the management company explain the issues to the customer properly.
I understand from that, if DLD has set foot to send those Molak and invoicing, that means no one can charge any owner unless it's approved by DLD.
Exactly. With the introduction of the auditors and the tapes and everything, you basically cannot just come up with a random number and say this is your service charges. Previously, with the introduction, whenever you see a community evolving, the first service charges, or back in the days where service charges used to be designed, right now you have more control where the service charges is designed by the community management team. It goes to the auditors, it goes back and forth. So you basically have a dialogue between multiple parties who are professional in their own standards. So when you have an OA manager with, let's say, past 8 years of experience, he knows what a community is. And when an auditor comes in, he also wants to make sure that the amounts are audited and make sure that it is in line with the market numbers. So it is a great concept of, the numbers going back and forth and basically making sure that the community is properly looked after. So
Thank you,
I
Mr.
believe
Samuel.
Molak is establishing everything properly.
Thank
So,
you, Mr. Samuel. Mr. Wakar, in line with what RERA is trying to clarify, make things attractive to investors, make things straight, what other procedure were introduced by RERA in line with the new law to help GOP?
This question is linked to the earlier question that you asked, Sam, about how does the new law attract more investment into Dubai. So I have a slightly different opinion on that. My take is that the law does not directly influence investor decisions, because investors look at return on their equity. Investors are not really bothered about the nitty-gritty operations of the community. So the law does sort of address homeowner issues. People who want to live in the projects, they get more say in it. However, it does contribute indirectly by creating an environment with more transparency. So, because a lot of investment in Dubai came when even there was no owner association law. So the investors were hopeful of they had confidence in Dubai and they had confidence in their return. So that confidence of return is what drives the investors. However, this law does contribute indirectly in creating an environment of transparency where investors will be confident that once they buy into the projects, they will not be taken for a ride and charged unreasonable service charges.
So if we say, go ahead.
Yeah, and now the other part of how the new law has, added more tools to make sure that there is transparency. So now there are two projects which came in side by side, which is the Mullak project and the law number 6, and they both complement each other. So now with the Mullak, as Sam already explained, the ownership data is directly picked up from the land registry. The budget is reviewed by a third party, and there is a paperless process for invoicing, and there is a regulated account, which is the cornerstone of, I would say, this new arrangement. Earlier, the funds, big funds, huge amounts, were lying either with the developer or the manager. Now, those funds are in escrow accounts. So those are regulated accounts which by law cannot be used to settle the debts of the management company. So there is a protection that the funds for the properties are secured in escrow accounts and can only be spent in accordance with the regulations and rules for the property. So this is, I think, one of the most significant achievement of the new law, that the huge amount of money is now secured in escrow accounts rather than lying unregulated with different entities.
Thank you. That's my exact point with Wakar. So what Wakar said, which I don't agree, it has a direct impact. So anytime you have an investor looking into Dubai, they're not just looking into projects, they're looking into what the developer or the manager has done. So there have been multiple cases where the manager has failed to check the developer accounts. And right now with the introduction of Molak, you see a lot of trust being created. And this is also leading to happiness, which is the important facet of Dubai. To create happiness, you have to make sure that everybody is transparent, and these regulated accounts attract investors.
Mr. Garage, would you elaborate on this two gentlemen talking about improving confidence and trust? Will that be detected or reflected in a lower service fees charges?
100%. What these two gentlemen equally contributed each other, and the current aim with every single person in the community, as a manager or individual working in the company, start from top to bottom or bottom to top, regulatory to till now. Our all aim to making sure that our quality of service remains same, and we also ensure that the prices are drop down to contribute. That means what you pay, the value for the money is being taken into account already. For that, RERA has established certain process guidelines, and there's a third party being appointed. That's what they're talking about, oversee the process, making sure that this is one of the primary objective, that every single person working in this community or industry must understood, must go through the process to ensure that your community service charges are well optimized without compromising the quality of the services. So that's been very well addressed and very well taken care by them.
Sounds great. You know, everybody is looking to lower that, especially during this tough time of the return, which is lowered as well. Yeah.
With COVID and everything, it becomes very hard for people. There's been a lot of job cuts. There's been the economy going down. You also see the rentals going down. So literally people are being attacked from all the sides. And 2020 has been a tough year.
Very good, very good. Now, go ahead. I was reading some of the chat question, guys, and one of the questions says, we used to have the GOPD, the declaration, jointly owned property declaration, which has been canceled according to the new law now. Now we have instead the BMS, Building Management System. Can you just elaborate a bit, any of you, tell us exactly when is BMS prepared, who approves it, and is there any changes during the run of the year?
Before we talk about the BMS and that, just a brief point on lowering the service charge. While it is important that there should be no inefficiencies, the service charge should be fair. Now, expecting that service charge will be lowered is an unrealistic expectation. Some of the properties are now 10 years old, 15 years old, and the maintenance costs are going up and up. It is very simple. Even though the economic situation may not be good, but when we take our car for a service, now we do not expect that the service cost or the oil change cost will be half or lowered. The oil, it will more or less be the same. And if our car requires more maintenance, it is going to cost more. Same applies to the property. So if a property requires more maintenance, then the service charge should fairly reflect that. And if there are any inflations or any inefficiencies, those should be like through energy management or cutting some frills here and there. Service charge should be brought more in line with the expectations, but I strongly oppose the view that it should be, across the board just lowered. That may have a very, very negative long-term impact.
It depends on the level of the maintenance that this
exactly.
Yeah, this area is requiring. Yeah.
In connection to what Bakar said, I love Bakar. Bakar is my friend. We've known each other, so we are not fighting over things.
You don't have to express that. We can feel it.
But what happens in properties is that you comparing a property to a car, it's okay. But the problem is a car at the end of the day, it's not if you are making sure that your car is, being compared to a property, what if the car's mileage is going down every month? Because you don't assess a property just by looking at it. Even though, the people buy into property by just feelings, you tend to compare your rentals, your receivables to your outgoing. So when you look at a commercial property, you look at more money coming in, but when you have a residential property, you do not actually have more rental coming in, but your rentals have been falling over the years. So when you have an investor, okay, let me compare myself, talk about myself. I have 2 properties, right? So as a normal person owning 2 properties and not having a large scale, 15 properties, for me, every dollar counts or every dirham counts. So when I see my rentals going down year on year, and my service charge is going up, I accept that you're a professional and you understand your industry, you understand the market, you understand why a cleaner has to get paid so much and why Sierra has to cost so much. I understand you're a professional, but if I'm an investor, I don't care about these things. For me, it's only one thing. What is my ROI? What is my return of investment? If my return of investment is going down the drain, I'm not going to be motivated to invest in a community anymore. There are communities that are amazing. There are villa communities that have been amazing. But the problem is both of us, me and Makar, we own a community. We have invested in a community personally, and the rentals have gone down. We both complain. And if the OA manager of that community is going to come to me and Makar and say, you know what, understand this, our OA personality doesn't kick in, but our consumeristic tendencies kick in, and we're going to get annoyed. So the issue is, service charges going down is something traditional and everybody expects it. Even though it is something that we understand professionally, it may not happen. But as consumers, we expect it to happen. Everybody loves finding a good deal.
Can the land department or RERA or you as managers of those big companies interfere to try to get cut on the cost or expenses, let's say talking to insurance companies or trying to lower the insurance installments, or talking to DY itself, try to lower the consumption and so on, being served to big communities?
What we are seeing is that since the introduction of MOLAC, it's not been a random change or a rapid change. Rather, it is designed what Kanagrad said. It is designed to take its course and make sure that the changes or the consequences of what is going to happen. Because tonight you can change the entire law, but how is it going to affect everybody else? And with the introduction of the law, I believe this is what RERA and DLD has done. They have made sure that every year has a change. And I can definitely say that in the next 2 or 3 years, you're looking at the market levels being extremely high, your rentals being high, and also making sure that the market is sustainable. And it's a process where everybody wins. And this is what I believe RERA's concept is, RERA and DLD. So this is my 2 cents. Sorry, Bakar, sorry for bothering you.
That's okay.
Let me add to that. Economic changes they're slow to affect, or we see the results of economic changes slowly. So with this COVID recession, the new law, I see that the inefficiencies in the management and operations of the buildings are slowly, cutting down. So if people had some extra budgets, just in case contingencies, so those have been cut down. There were some reductions in utility expenses from the government to subsidize the electricity costs. So those things. And secondly, as rents are going down, so now the suppliers, the maintenance companies, the cleaning, the security, now they are paying less for their labor accommodations. Now the executives are paying less for their own accommodations. So gradually, those reductions in accommodation costs are going to affect the cost of services. So we are going to go back to the facility management company, the security company, the cleaning company, and even that, the cost of living is coming down. So should your fees, and that is going to slowly, and it is affecting. Now we see that, there is a few feels reduction every year in the budget. And that is because the cost of living is going down in the country, and that is going to ultimately affect the.
As we mentioned at the beginning that we got to hear good news, we're almost out of time, but let me just elaborate on a couple of minutes of points about the questions on the chat. On the BMS, I understand that BMS is prepared by the management company and approved by RERA, right? Some other question is asking about who signed the agreement between the company and the agreement contract. Of course, the management is appointed by the master developer. So the agreement is signed between both of them. And when the committee is finding that the job is not done correctly, so RERA had the right to switch or change the company. One more thing, it says does RERA ask for comparison of supply and agreement? Like we used to ask for quotation on the old in the old law. I don't think here is quotation. It is the management company that takes care of that, unless you have anything else to add. Anything to do with defaulter or those people who did not pay, legal action to be taken, or anything else, and when that will take place, if any?
That is something which is going to be clear in coming days. Now, as the RDC is taking approach, and we see that slowly the decisions are coming out. However, there is still a soft approach because of the overall economic situation of the world. So I believe there is a general soft stance. However, that is going to, it is expected to be stricter in the future.
1 minute each, if you can just give me a final conclusion, final word, the final suggestion to owners and to Dubai.
What I can say is you are in for a good long-term investment. What has happened in previous is it was short-term flipping, but right now Dubai is looking at long-term investment, and I believe that is the way to go. And thank you for giving us the opportunity to community management, and thank you, George.
Thank you, Samuel. It's a pleasure.
The market, as Sam said, market is now more oriented towards homeowners rather than big-time investors. So homeowners are getting more advantage in this current market. And yeah, it's definitely a good investment because the return on investment overall, even when the rents are going down, the prices are also affected. So looking forward, the returns are also decent and the market is stable.
Mr. Wakar,
To
thank you.
add that one, that market we are into sustainable market. It's going to be sustainable for in future. The owners or the carpets are really open for you. You have, full confidence on the government and the industry and the experts, the expert, the management company to regulatory, as well as that the owners been.
The sound?
I think the connection is not.
The
It's
connection
not proper
is
now.
okay.
Yeah.
All right. Mr. Kanagaraj, thanks a million. Mr. Wakar Hassan, appreciate your participation and your input. Mr. Samuel Joshua, it is a pleasure always to hear your comments and input. And I hope that everyone in the audience has really got some advantage of listening to your positive and enthusiasm and the future that really had the law introduced to Dubai, and the trust and confidence that we will be built, as a matter of fact, for all reputable Dubai, as it used to be always, and it will continue to be for.
Kanagraj, you're on mute.
Yes, I can. I think the sessions are get over. That's what I could see. 150 already, right?
Yeah, 152.
Yeah, that's one of the reason. I could see that, because other sessions they have to start on time. That's where it's flipped. I think we have come to the end. I think it's wonderful. Yes, George also back.
You're on mute, Dr. George.
You're on mute, Mr. George. I think it seems to be now you are be the host now. Bakar, you are be. I think you're.
Okay,
Yes.
I'm muted now. Dana, we still have audience. Do you still have any question to add? Okay, we thank you again for your participation. It was a pleasure having you, and I guess this is not the last meeting. We will be all together talking to our investors and esteemed owners, but we will meet again and again. Most probably, COVID will be just a past, a history, and we will all gonna meet face to face pretty soon and get more things done accordingly. Thank you, everybody. It was
Thank you so much, George, for your wonderful session. Thank you, Wakar, and thank you, Sam, for your support. Thank you all. See you.
Thank you. Dana, do you need to add anything? Okay.
See you.
Take care. Take care, everybody.
Bye.
Can you do me a favor? Can you tell Fahim to send Jeevan's again with his logo?